So, Dan and Brendan back to talk about a little more law and public policy type stuff. And Dan, you're the one who noticed this. You sent me an email about it. I'd like to say it's completely unbelievable that this has to be some kind of a joke, but we do live in America.
Yes, we do.
I don't know that I'm really capable of being surprised anymore. So what struck your eye? You saw a story and you sent it to me.
There are people in Alabama who are having COVID parties, believe it or not. This whole thing just sounds perverse, I know, but it's true. It's documented. A bunch of people get together for a party. They put some money into a pot. They invite to the party people who they know have active COVID virus going on, so that everybody at the party gets exposed. And then the first person who is diagnosed with COVID as a result of having attended the party wins the pot full of money. I wish that I could say this is a joke, but this is not a joke. So when I read this thing, the first thing that came to my mind was, what a bunch of morons, first of all, and what absolutely incredibly terrible people these are. Look, if you want to kill yourself with COVID virus, if you want to show up at one of these parties and get the virus and risk your own severe illness or death, I really couldn't care less. I support your right to do that. How's that? Where I have a problem with it is that you're not the only person that you are jeopardizing with your monumental stupidity. You're going to take that virus home to your spouse, your children, your parents, your grandparents. You're going to take it to your workplace and expose your coworkers. And these people, presumably, had the good sense not to be stupid enough to go to a COVID party to try to win a pot of money by getting the disease. So the question that we thought we would take up is, if you're one of the idiots who does this sort of thing, is there the possibility that either civil or criminal liability might attach if you then turn around and expose other people to the virus as a result of your incalculable stupidity? So why don't you, Brendan, if you would, start by talking about the potential for criminal liability, and then we can sort of segue into civil liability.
Yeah. So as always, we're gonna make a few overriding big points here. And so first, we'll talk about the state of mind that's necessarily that's usually required for any kind of legal liability, and then we'll talk about that'll be point one. Point two, we're going to talk about this element of almost any legal claim called causation, and how that could pose a problem in any prosecution or any lawsuit about this. And then finally, Dan, you're going to talk about insurance carriers and how they might opt out, right, of defending these idiots, or not even if they defend them. What's that?
I said, surprise, surprise. Insurance companies aren't going to be thrilled to be on the hook for this stupidity.
Right. So those would be the three big points. Okay, so whether it's a criminal case or a civil case, most of the time liability attaches for some kind of wrongful state of mind. And when it comes to criminal liability, it's usually a little bit more, right, a wrongful, right, whatever state of mind is required under a criminal statute. Now, I did a little research on this. I certainly haven't become an expert on it. But when it comes to spreading disease, a lot of states do have laws that criminalize the spreading of disease, but they tend to the more puritanical side of things, right? We as a society tend to obsess on sexual issues. So most of the time, if you see a state expressly or explicitly criminalizing the spread of a disease, it's usually HIV or some sexually transmitted disease, which kind of raises the question whether, if you have statutes that criminalize the spread of those diseases, but not diseases like this one, would a court go there? However, There are general criminal laws that cover injuring people or killing people, with the states of mind that generally, Dan, I think as lawyers we divide the wrongful state of mind, scienter, right, a fancy term for it, or if you're talking criminal law, mens rea. If anybody wants to do a party trick and start talking Latin. The three states of mind would be intent, right, where you act with purpose to do something, recklessness, where you are aware of a serious risk that your conduct poses and you do it anyway, so you actually know the risk and you do it anyway. And negligence is where you're an idiot and you should have known the risk. Right? If I say you're negligent, I don't have to prove that you actually knew the risk. I have to prove that a reasonable person would have known the risk, and you are an idiot.
Right.
To put it bluntly. When you look at and criminal laws, of course, vary from state to state. So neither one of us knows what Alabama's criminal laws say. But when you look at this conduct, at the very least, it's negligent. These idiots should know better. And I would argue it's quite obvious that it's beyond negligent, that it's reckless.
Yes.
There's no way not to understand the risk that you're creating for other people under the circumstances. Going above that to intent, but probably a difficult uphill battle to show that. But it seems to me like this is reckless, to say the least. Would you agree?
Absolutely, yeah. I think that what we're talking about is criminal negligence or criminal recklessness. And of course, that sort of leads us to the next point, which is not the next point, but related to this issue of causation. In the criminal context, the burden of proof beyond a reasonable doubt. Why don't you talk about that too?
Yeah. So, what Dan's talking about there is when a prosecutor brings a criminal case, the prosecutor has to prove the elements of the crime, right? These crimes are element driven. And in a civil case, we call it a tort instead of a crime. And usually torts have elements too, like the tort of negligence has elements. And the way elements work is that whoever's bringing the case, whether it's a prosecutor in a criminal case or a plaintiff in a civil case, has to prove the elements of the cause of action. The bad news for any prosecutor or any plaintiff in one of these cases is going to be that no matter what crime or what tort you're talking about, most of those have a causation element. And that means that whoever's bringing the case has to show that the defendant was not only a but-for cause of the injury or whatever harm happened, but was the proximate cause, right? The leading cause, just to kind of generalize here, of the injury. And in sort of a perverse way, perverse is our word of the day here, in sort of a perverse way, the coronavirus, the nature of the virus, works in favor of these idiots in this case, because it spreads so easily, it is so virulent, that it would be very difficult for any plaintiff or prosecutor in a criminal case or plaintiff in a civil case to show who infected whom. We have these super spreader events. We have people getting sick even when they're staying at home and using precautions, right? So it would be very difficult to show that one of these people who was attending one of these parties, that they are the ones, when they went home, when they went back to work, whatever the case may be, who caused the injury to somebody else. But Dan, now I'm going to throw it back to you. It would be easier to show in a civil case, a torts case, than it would be in a criminal case. And that's because of what you just mentioned, which is the burden of proof.
Yes. In a criminal case, we all know from our fond days of watching Perry Mason that the burden of proof is beyond a reasonable doubt. And that is a very, very high standard for the state, the prosecutor, to meet. The same standard, though, is not present in a civil case. In a civil case where you're not looking to throw somebody in jail, you just want money damages from them, the burden of proof is something called preponderance of the evidence. That means that the party that's seeking to prove the case does not need to show that this person infected me beyond a reasonable doubt, only that this person, more likely than not, by a preponderance of the evidence, is the source of my infection. Now, in either case, whether it's civil or criminal, you're going to have expert witnesses of some sort who will take the stand and testify as to the nature of the COVID virus and how we contract the virus and how we transmit the virus and transmission patterns and all of that sort of thing. But the takeaway point for our purposes is, in a criminal case, very high standard of proof beyond a reasonable doubt. In a civil case, preponderance of the evidence, slightly more likely to be true than not true.
Right. And it seems to me that, if one of these people, shows up at work and nobody at work was infected before this person went to the party and now they're all infected, you may not be able to prove beyond a reasonable doubt that this idiot was the source of the infection, but it certainly seems more likely than not. And I bet most jurors, let's not overlook that. Juries are human, they get angry, right?
Yep.
I bet most juries would agree with that. So, and why don't you explain, Dan, what's going to happen when one of these people turns around and asks their insurance company to cover them?
Well, yeah, this is where things kind of get interesting, right? So if you're one of these maroons who has one of these parties at your home or your apartment or wherever, and then some people show up and get infected and they take the virus home to their family members or to work and their coworkers, and all of a sudden you find yourself getting served with lawsuits left and right from people who were exposed to the virus because of you being stupid. One of the first things you're going to do is take that lawsuit and hand it over to your homeowner's insurance company or your renter's insurance company or whatever the case may be and say, cover me for this. Insurance companies, not surprisingly, are likely to look askance at being on the hook for you being so remarkably stupid. All insurance policies have exclusions of varying types, including exclusions for intentional acts, as well as, in some cases, exclusions for grossly negligent conduct or reckless misconduct. And so what's likely to happen, the threshold for having to defend a case tends to be lower than the threshold for having to pay off on a verdict. So what's likely to happen is an insurance company will say, we will defend you in this lawsuit on something that's called a reservation of rights, which basically means we're going to go ahead and provide the defense at our own expense for now, but if things go south or a jury concludes that there is liability here, we reserve the right to turn around and walk away and say we ain't paying. That's likely to be what an insurance company would do in a case like this. But to make a long story short, you can bet that insurance companies will be looking for any and every policy exclusion they can hang their hat on to decline coverage for this kind of an occurrence.
Excellent. So in other words, if I were to summarize that, the insurance company is going to tell you to go pound sand.
If it comes down to a verdict, yes. The insurance company is going to say, we don't believe that the terms of our policy require us to indemnify you, our insured homeowner or renter, for the damages that the jury found here. So if somebody ends up with a $500,000 verdict against you, guess what? No insurance to cover that. You're going to have to make a beeline for your local bankruptcy court and file for bankruptcy, or let the plaintiff execute and take your home and your car and your dog and your computer and all that kind of stuff.
Mm-hmm. Excellent. All right. So the 3 points, if you're thinking about going to one of these COVID-19 parties, number one, your state of mind might be wrongful enough that it would expose you to liability, either civil or criminal. Number two, particularly in the civil context, it may not be that hard to show that you caused, right, even though there's a causation element, that you caused harm to others. And finally, if a jury does find that, or if a court does find that, you're barking up the wrong tree if you think your insurance company is going to cover that kind of wrongful conduct. Fair enough?
Fair enough, my friend.
All right. Well, the next time we see something extraordinarily stupid, which should take about 12 hours or so from now, we will reconvene. If you like this video, please remember to click like and subscribe, and click on the little bell that's down there somewhere that notifies you of new videos, and share it as well. Until then, until we see you again, stay well and stay tuned.
Thanks, everybody.